time there's a shooting, we play this ridiculous theater.
Over and over and over again. It begs the damn question, what the hell's going on in the United States of America?
That an American citizen, a threat to themselves or others.
Restrictions on concealed carry being struck down by the Supreme Court.
Would you go to your neighbor's home and confiscate his legally owned weapons, a man that was not under criminal investigation nor under arrest? Would you do it?
The Supreme Court of the United States is about to issue one of the most consequential Second Amendment rulings in 4 years. The case is Wolford v. Lopez, docket number 24-1046. The decision is expected as early as Thursday, June 18, 2026. And based on what happened inside that courtroom on January 20 of this year, the government is going to lose. I'm going to break down exactly what this means for your carry rights, which states get hit, and what you need to know before Thursday morning. If you hold a concealed carry permit and you live in Hawaii, California, New York, New Jersey, Illinois, Maryland, Colorado, or Washington State, this ruling is going to change where you can legally carry your firearm. Not eventually, not in some theoretical future. The day this opinion drops, the legal ground in those states shifts. So let me walk you through every piece of this, what the law says, what the court said, and what comes next.
The Supreme Court overturned a federal ban.
The Supreme Court has recklessly struck down state law that limits those who can carry concealed weapons.
Here's the law at the center of this case. Hawaii enacted Act 52. That is the statute being challenged in Wolford v. Lopez. What Act 52 does is something that should make every gun owner in America pay attention regardless of what state you live in. It represents the most aggressive post-Bruen strategy that state legislatures have tried. Act 52 reverses the default rule on private property. Under traditional American property law, which has been the rule in this country since before the founding, if a business owner does not post a sign prohibiting something, you are generally permitted to do it. That is the presumption of permission. You do not need an invitation to bring your legally carried firearm into a restaurant that has not posted a no-gun sign. Act 52 flips that completely. Under Act 52, if a business owner has not posted an explicit sign welcoming firearms, your gun is banned. The law presumes you are not wanted. It presumes your constitutionally protected firearm is unwelcome everywhere, in every business, in every store, in every restaurant across the state of Hawaii, unless someone actively invites you in. Gun rights attorneys started calling it the vampire rule immediately, and the name stuck because it is accurate. The government is treating your Second Amendment right like something dangerous and unwanted that cannot enter a space unless it is formally invited. That is the law the Supreme Court is about to rule on.
Sworn to uphold the Constitution.
The impact of these laws and helps us to have an educated, informed conversation as a country about what actually works.
Are losing children due to the guns and the carnage and the lawlessness unleashed by those states.
California passed its own version. Senate Bill 2, which is California's post-Bruen response, works on the same principle. It designated so many categories of locations as sensitive places where carry is presumptively banned that gun rights groups argued it effectively nullified the right to carry a firearm outside your home in practical terms. Both laws were defended together in this case. Annie Lopez is the Attorney General of Hawaii and the named respondent. Jason Wolford is a Hawaii resident who holds a valid concealed carry permit and sued because he could not legally carry it anywhere meaningful. That is why it is Wolford v. Lopez. The Ninth Circuit upheld both laws. The Ninth Circuit is the federal appeals court covering the western United States, and it has a long track record of ruling against Second Amendment challenges. The Ninth Circuit found that Hawaii and California had the authority to impose these default restrictions on where permitted carry is allowed. The challengers appealed to the Supreme Court, and on October 3, 2025, the Supreme Court granted cert rari. That means the court agreed to hear the case. They did not have to take it. The Supreme Court receives thousands of petitions every term and agrees to hear roughly 60 to 80 of them. The fact that they took Wolford v. Lopez is itself a signal that a majority of justices believe the Ninth Circuit got it wrong.
This committee gets together and proposes a bunch of laws.
A piece of legislation changed their ability to hold a concealed firearm permit.
Oral argument happened on January 20, 2026. The session ran close to 2 hours, which is significantly longer than a standard argument. And what happened during those 2 hours was about as clear a preview of a court's thinking as you will ever see. All 6 of the Republican-appointed justices, Chief Justice John Roberts, Justice Clarence Thomas, Justice Samuel Alito, Justice Neil Gorsuch, Justice Brett Kavanaugh, and Justice Amy Coney Barrett, spent their time pressing the government's lawyers. They were not satisfied. They pushed on the historical record. They pushed on the scope of the restriction. They pushed on the logic of flipping the default rule. The lawyers defending Hawaii and California struggled to answer the central question: where in American history has any government presumptively banned firearms from all private commercial property open to the public? The answer is nowhere, because it has never existed. Now I need to explain Bruen, because this entire case is built on that foundation. New York State Rifle and Pistol Association v. Bruen was decided by the Supreme Court on June 23, 2022. The vote was 6-3. Justice Clarence Thomas wrote the majority opinion. The court held that when any level of government wants to restrict Second Amendment rights, it cannot simply argue that the restriction serves public safety or is good policy. That is not the test anymore. Under Bruen, the government must demonstrate that the restriction is rooted in the historical tradition of firearms regulation in the United States, specifically at the time of the founding in 1791 and during the Reconstruction era around 1868. If you cannot produce a historical analog, a law with a comparable justification, a comparable burden, and a comparable effect, the restriction is unconstitutional. Hawaii and California both tried to satisfy that test. Their lawyers argued before the court that sensitive places restrictions have always existed in American law, and that is partially true. Historically, governments have restricted firearms in specific locations: legislative chambers, courthouses, polling places, schools, churches. Those restrictions have historical support. They have founding-era analogs. But here's the critical distinction the justices kept coming back to. Those historical restrictions are specific and narrow. They apply to particular defined locations with particular characteristics. Act 52 and Senate Bill 2 are not narrow. They do not restrict carry in specific defined sensitive places. They restrict carry everywhere by default. Every restaurant, every grocery store, every bank, every pharmacy, every retail business in the state. The government could not produce a single historical law that came close to imposing that kind of blanket presumptive ban. Justice Gorsuch said directly during argument that the scope of the Hawaii law appeared to have no historical parallel. Justice Thomas pressed the government's attorney on whether there was any founding-era law that presumptively excluded firearms from private commercial property. There was not. The honest reading of what happened on January 20 is this: the court is going to strike down the core of these laws. The question that is still genuinely open is how broadly they write the opinion. Do they issue a narrow ruling that addresses only the specific provisions of Act 52 and SB 2 as applied to the parties in this case? Or do they use Wolford v. Lopez to establish a broader rule about what the Bruen standard means for sensitive places doctrine going forward? That distinction matters enormously, so let me be precise about why. A broad ruling would set a national standard. It would tell every state legislature in the country that sweeping default bans on carry in private commercial spaces are unconstitutional. It would effectively resolve dozens of pending challenges to post-Bruen laws in New York, New Jersey, Illinois, Maryland, Colorado, and Washington in a single opinion. Those states enacted their own versions of expanded sensitive places laws after Bruen, specifically to limit the practical impact of that ruling. New York's law designated Times Square, the New York City subway system, and most commercial businesses as sensitive places where permitted carry is banned. New Jersey, Illinois, and Maryland followed with their own versions. If the Supreme Court writes a broad opinion in Wolford v. Lopez, all of those laws come down simultaneously. A narrow ruling, on the other hand, leaves those challenges to play out in the lower courts. A narrow ruling would still strike down Act 52 and SB 2 as applied here, which matters for Hawaii and California gun owners, but it would give New York and New Jersey more time to defend their versions of the same laws before the same legal logic eventually catches up to them. There is also a second major gun case sitting at the Supreme Court right now, and you need to be aware of it because the court may issue both decisions in the same week. That case involves whether the federal government can criminalize firearm possession by a habitual marijuana user, even in states where marijuana is legal. Federal law, specifically Title 18, United States Code, Section 922, which is the main federal firearm statute, says you cannot legally own or possess a firearm if you're an unlawful user of a controlled substance. The court heard arguments on this question earlier in the term. Their decision will affect an estimated 50 million Americans who live in legal weed states and also own firearms. The court is expected to uphold the prohibition, but the opinion will likely address what unlawful user means under federal law. 2 major gun decisions potentially in the same week? Now let me be straight with you about what Wolford v. Lopez is and what it is not. Because I'm not going to oversell this. This is almost certainly a significant win for concealed carry permit holders in the states that passed sweeping sensitive places laws after Bruen. If the court rules the way oral argument indicated, you will regain the legal right to carry in restaurants, stores, and most private commercial spaces in states where the default has been presumptive prohibition. That is a real practical change to where your permit is actually valid. For gun owners in California and Hawaii who have spent the last 3 years unable to carry anywhere meaningful, this is a meaningful expansion of your rights. What this is not, it is not the elimination of all carry restrictions. Genuinely sensitive places will still stand. Government buildings, schools, courthouses, polling places, those restrictions have historical support and will survive. What this decision is designed to kill is the tactic of designating everything as sensitive so that your permit becomes worthless in practice while remaining valid on paper. And one more thing deserves honesty even after this ruling. Individual business owners retain the right to post their own no firearms signs under state trespass law. A win in Wolford v. Lopez flips the default. It does not eliminate the choice. Businesses that genuinely do not want firearms on their property will still have a legal mechanism to say so. The difference is that you will no longer be presumptively banned from every commercial space in your state unless someone actively invites your legally carried firearm inside. That presumption of prohibition is what dies with this ruling, and that is not a small thing. Here's where things stand right now. The next Supreme Court opinion day is Thursday, June 18, 2026 at 10 a.m. Eastern. The court has additional opinion days scheduled through the end of June. The term closes by June 30th. Wolford v. Lopez will be decided before that date. If it does not come out Thursday, the next opportunity is the following week. If you carry a permit in Hawaii, California, New York, New Jersey, Illinois, Maryland, Colorado, or Washington, do not change your carry habits based on what you think the ruling will say. Wait until the opinion is published, read what it actually covers, and know which specific provisions in your state's law it addresses. A partial ruling or a narrow ruling could leave some restrictions in place while striking others. The Supreme Court drew the line in 2022 with Bruen. Wolford v. Lopez is where they enforce it. That is it for today. See you in the next video.